for the last year's first district's here. It is, yeah. So it's that. Mute and before. Oh, okay. Yeah, go. You on the first district. Let's say.
It's first district. Is that okay? Everybody can read it.
I called the lady Thursday, Friday. She was there this morning. She said she was after the list this morning. So that's democratic. Yeah.
All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Candace House presiding, is now in session. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. We have 4 cases up for argument this morning, and we're going to be taking them a little bit out of order. I will read the cases off that it will be argued, and if the attorneys would please note their appearances. The first case we have up for argument is State of Ohio versus Mounts. It's C210608.
Your Honor, Paul Crouch,
Good morning.
Your Honor, please start with the state.
Good morning. The second case up for argument is case number C220502, the OLB Group Inc. versus Blue Square Resolutions.
For appellant, Oliver Griffin.
Good morning.
Yes, sir.
Good morning.
Morning, Your Honor. Brian O'Connor for the appellate, the OLB Group, March 7th.
Good morning. Next up, third case will be C230013 and 014, State of Ohio versus Hobel.
Tanner Duggan on behalf of the appellant.
Chris Concer for the city of Cincinnati.
Good morning.
Keith Sauer for the state.
Good morning. And the final case to be argued is C220125, State of Ohio versus Sannon.
Laura Peters for the appellant, Sarah Nelson also for the appellant.
Good morning.
Judy Lack for the city.
Good morning. All right, so we are starting with State of Ohio versus Mounts. And Mr. Crosher, would you like to reserve any time for rebuttal?
Thank you, Your Honor. May it please the court, I would ask for 3 minutes for rebuttal.
3 minutes. All right, and I will use the lights on your podium to let you know how much time you have. The yellow will come up when you have 1 minute left of your initial time.
Thank you, Your Honor. May it please the court. This is a murder case in which Joshua Mounts did not receive a fair trial. He's been in prison for 1,893 days, custody in 1,893 days. And the primary problems that I'd like to address to the court relate to noise and bias, specifically the variability of the physician judgments, which should be identical. You would expect them to be identical, and yet there's a dramatic difference in what they found and what they opined, leaving it questionable whether an offense occurred at all and whether Mr. Mounts should properly ever have been charged, having been through the trial. And my first assignment of error is...
Well, I understand the difficulties of this case. with regard to that portion, hasn't that ship sailed? Isn't that really something more properly to be argued, for example, at closing with the trial court?
Well, Your Honor, the defense did not make a Rule 29 motion at the end of the evidence, but our authority in this district is different from most of the state, and he has not waived that, if that's what you mean. But I think the trial judge should have granted the Rule 29 motion at the end of the prosecution's evidence, should have taken the case from the jury at the end of all the evidence, based in part between the variability in the physician's judgments, including Dr. Weens, who was hired by the prosecution and who disagreed completely with Dr. Dean as to whether an offense occurred at all. And then we have this whole slew of trial errors of the appeals to the bias of the jury in closing argument by the rebuttal prosecutor. The limitation on the defense expert's testimony when the prosecution's experts were free to opine at great length outside the bounds of their reports, and yet everything from the prompting by the judge of the prosecutor as to isn't there a motion you'd like to make here, whereas at the end of the trial he doesn't even do that to the defense attorney on this Rule 29 motion.
I want to get back to what you just talked about with regard to the 16K report. Because as I understood the record, the experts of the state were talking about the difference between the original and the recut slides, right?
Yes, ma'am.
Is that really expert testimony at all? Did that even require for it to be in the 16K? Because they were not testifying about the condition of the body. Isn't it akin to someone discussing the difference between an MRI and a CAT scan with regard to a certain procedure?
Well, in, I think it was State v. Long, this court, State v. Hall, in 2019 Ohio 2985, this court addressed what actually is an expert opinion, and basically this panel held, well, part of this panel held that the detective's opinions were expert, and by failing to have him qualified as an expert and failing to have him do a report, the prosecution erred to the prejudice of the defendant.
Right, if it's an expert, but if it's simply what's the difference between original and recut, is that really expert testimony? Which really goes to your point of whether your expert should have been excluded in discussing more or less the same.
Well, Dr. Dean had talked about it in her testimony. She hadn't put it in her report. She talked about it in as far as what the implications of it being a recut slide was. She raised it at trial. Dr. Weens was attempting to clarify that her opinion would not change from that. And there were, in fact, defense counsel put on a proffer that she would say that her opinion is not changed by that.
Can you help me at least understand the significance of this? Because I read the expert testimony, and my understanding is that the recut slide can differ slightly, but it's basically a Xerox copy of the original, right?
Yes, ma'am. A slightly different layer by microns,
Okay.
I think is the term.
Okay, and the state expert testified that if there would be a significant difference, that she would call that to the defense expert's attention.
Yes, ma'am.
Usually. Okay, so why is this particular line of questioning and testimony between the original and the recut so important in this case? Because I didn't think that the state expert testified that the defense experts were wrong because they relied on a recut.
Because of the rebuttal prosecutor's closing, Your Honor.
The rebuttal closing.
Yes.
And what did that do?
He actually said that
Which expert was this on rebuttal?
is the rebuttal testimony by the prosecutor, Your He said,
You mean the rebuttal closing argument?
yeah, well, you would think that, but he's vouching for his
Okay,
witnesses.
okay.
He's asserting that other doctors agreed with his witnesses, but they couldn't be called because there wasn't enough time.
But it wasn't a rebuttal expert testimony. You're referring us to the rebuttal closing argument.
Yes, ma'am.
About why this was so significant.
Right, the recuts was about how their
Did the defense abandon Dr. Weems' testimony in this regard? I'm looking at page 1465 of the transcript, and defense counsel says, I can move on from this line of questioning of Dr. Weems regarding the recut slides before the court makes a ruling as to the state's objection.
Yes, ma'am.
So did defense counsel abandon this line of questioning regarding the recut slides and the difference from the originals?
Well, two things. First of all, I am specifically not arguing ineffective assistance of trial counsel on behalf of Mr. Mounts, because there's a number of issues that may have been waived. But in this case, I don't think he waived because of the reliance upon the recut in closing arguments by both, actually, as I think about it, by both the initial prosecutor and the rebuttal prosecutor, talking about the value of the recuts and how you can't trust Dr. Weems' testimony because she didn't look at the original, but she'd asked for the original back when she was a prosecution witness. And so his implication, it's the prosecutor's use of the recut issue that is I believe is the objectionable part, because like that Hall case, it's a bolstering by the attorney of what the witnesses were talking about, not so much what the witnesses were improperly
So
saying.
your real concern is the prosecutor's closing argument.
That is a key factor, yes, Your Honor.
And was there an objection to that particular line of closing?
Your Honor, there was only the one objection by defense counsel in closing, but here there were, I think, 11, I think I counted 11 defense objections in total in this whole trial. Trial court overruled 6, sustained the one after an extended sidebar about what Dr. Chundru thinks of the justice system, and instructed but not rule on 4. So we don't have much of a record on the defense side of objections that were made. This is why I mostly am arguing plain error, that the judge should have stepped in when some of this gross impropriety, I believe, happened.
Now, the defense did object to the trial court's determination with regard to Ween's ability to discuss the original and the recut slides. Is that correct?
Yes, ma'am. It is. I think Dr. Ween's testifying as to her slides. 1465, I believe, is the page, which I think is in volume 25, Your Honor. And that is, the defense objected and was overruled. So the question then becomes is the combination of the evidence that, the combination, for example, Dr. Makarov being able to do opinions without having submitted an expert report about what the baby having a fracture and a skull bleed, Dr. Dean disagreeing with the children's doctors, but that gets glossed over by the prosecution closing argument that says all of the doctors agreed with the prosecution theory. So basically, they're sort of ignoring Dr. Dean's own testimony in closing about what the other doctor, about whether she disagreed with the other doctors.
Now, you had characterized this as a dueling expert case in your brief. One of the things that you complain of are these I ultimately counted 9 experts. There were 8, but then there was Dr. Schawbach, and I know I killed that name, that was discussed in closing as agreeing with Dr. McNull. So why don't you address that particular error that you raised in your brief?
Yes, Your Honor. These other doctors, or these other names that were cited by the prosecuting rebuttal prosecutor, we never saw them. He said he didn't call them because he didn't have time. He didn't want to drag out the trial, or I forget his exact words. But the implication is that they all agree with Dr. Dean. But clearly from what Dr. Weens had seen, she said that her opinion was that these other doctors had said the cause was undetermined and the manner was undetermined, and thereby agreeing with her. Dr. Dean said, I don't think Dr. Dean actually addressed, well, she talked about the radiologist not being qualified to render an opinion, but she didn't go into any of these other names. And then suddenly in the rebuttal, we have this whole long list of doctors' names that supposedly agreed with Dr. Dean, but we never saw.
So they were never, I'm sorry, so they were not part of the record, they were not part of the trial proceedings, they were not, their opinions were not submitted, but they were discussed during closing, is that?
That's correct, Your
correct?
Honor.
Okay.
I think I talked to Dr. Weens about it, and I think she said that a bunch of those names weren't doctors, and yet they're being portrayed as doctors, as experts. They're not experts. I mean, there were, I think, 6 real experts. Now, Dr. Dean wasn't qualified as an expert. Mr. Castillo, I don't know whether he was treated like an expert because he gave opinions. He rendered opinion as to what was normal, that Josh Mounts didn't act normally based upon him having been an EMT at deaths of things. He wasn't qualified as an expert, and yet he's rendering opinions. The people that were qualified as experts were varying degrees of qualification. The 3 defense experts were, in fact, board-certified forensic neuropathologists. Dr. Folkerth, who was the prosecution's videotape expert, and her depositions at trial docket 170, her report, I think 8, says that is headed that it's forensic neuropathology associates, and yet she's not a forensic neuropathology board-certified doctor. We don't know in the certificate of necessity that the prosecutor got the judge to agree to hire her. He said she was a forensic neuropathologist, but when she gets to her testimony, she's just done a lot of autopsies, and so she has none of those qualifications.
I do have one more question. Is there any reason that you did not raise cumulative error?
Because it was a judgment call, because I was at 8,999 words, Your Honor. It was my cumulative error was my weakest. Sufficiency evidence was I already had in, so I figured I wouldn't actually use the words cumulative error, because sufficiency evidence, I think, contemplates or includes that. I hope you agree with me.
You are at your time unless my colleagues have additional questions, if you want to reserve 3 minutes.
Yes, ma'am.
Thank you.
Thank you, Your Honor.
Thank you.
Good morning, Your Honors.
Morning.
May it please the court, Mr. Crozier. I guess I'll address the assignments of error in order, or at least as much as that makes sense to do so. In terms of whether the jury should have gotten this case to begin with, I think under the weight and sufficiency argument, at least in the reply brief, defense counsel relies on some outdated doctrine about the Cooley doctrine about the sufficiency of circumstantial evidence. I would just note that in this case, the 2 things that are looked at in terms of sufficiency for conviction for felony murder are, number 1, is did the defendant have sole custody of the alleged victim during the time that the alleged injury occurred, and is there medical testimony establishing that there was abuse. That's under the Butts case, Houndshell, Walker, and Kristen from the 2nd District. And I think in this case, those 2 elements are clearly sustained. There was no error in giving this case to the jury, and I don't think there's been any showing that that there was any that the verdict was against the manifest weight of the evidence. As to the recuts, I think this is a bit of a tempest in a teapot. I think when the recut issue was raised the first time, it appeared as though it might be significant to the ultimate determination of guilt in this case, but as it turns out, it wasn't. The quality of the recuts turned out to not be an issue at all. There was no implication on the part of the state's experts that the defense experts went down the wrong path in looking at the recuts, or that there was any insufficiency.
It wasn't in the testimony, but there was in the rebuttal. The state did argue such in the rebuttal closing argument.
Yeah, Judge, I understand that, but I think in terms of the relevance of these recuts, as it turned out, the problem that was addressed, or the problem that was identified by the state's experts, was that the defense experts were just looking at the wrong part of the slide, not that it had anything to do with the recuts. There's no objection to the prosecutor's closing in that regard, and I just think it doesn't have a lot to do with the ultimate issues in this case.
And why did the state try to preclude the defense expert from basically testifying that if they had the original slides, it wouldn't have made a difference to the opinion? I mean, why did the state try to keep that out?
Yeah, I don't know, Your Honor. I can't get into the mind of the trial prosecutor. I would note that at the time of the trial, when I was reading the transcript for the first time, I thought, well, this might be significant, and I think that that's probably what the trial prosecutor thought as well, that this might come down to a question of cuts and recuts.
But does that really have to be included in an expert? I mean, for either side.
Right.
I mean, we're talking about, and this goes back to Judge Zayas's original question, the opinion testimony in this case is what basically the cause of death is discussing that the recut and the original in this case is there's not much difference and it wouldn't change an opinion.
Right.
Does that need to be in an expert report?
I wouldn't think so, Your Honor. It's the 16K is fairly broad in its wording about what has to be included, but I'm not sure that this was an expert opinion. But again, I go back to the notion that even if it were, it just, as it turns out, it just didn't really have a lot to do with the ultimate verdict.
But isn't that hard to say, because this was ultimately a battle of the experts? It all hinged on these, I believe it was six testifying experts, am I right? And there was some variation between what they notated and what was significant and what was, the history of trauma that each one had discussed and so on. So you got a battle of the experts, and then you have a rebuttal closing argument that bolsters the state's experts on using the originals and and hammers that the defense experts did not use the originals.
Yeah, I understand.
Who are we to know what the jury,
Yeah.
how the jury called it?
Right, I
amongst
understand the
these
issue.
six experts.
I'll just fall back on the old saw that the closing argument's not evidence, and in this case there were no objections to that line of.
Counsel, let me draw your attention to the evidence.
Sure.
Dr. Dean did testify about this on pages 1234 and 1235. She's asked, is there a disadvantage to looking at a recut over the original? And she says there is somewhat.
Yeah, that's right.
So what impact does that testimony have on this issue?
I think very little, Your Honor, because again, the question of the quality of the recuts turned out to not be a determinative issue at all. The quality of the recuts, and what she testified to, is by all accounts accurate. That they're not, that because you're cutting through sections of tissue, that they're not exact duplicates, and there can be differences. But in this case, she didn't identify any difference that would call into question on the defense's conclusions. And as it turns out, the deficiencies found by the state's experts in the defense witness's testimony had nothing to do with the recuts at all. So I think, on the whole, if you look at the entire thing in context, that there was no reversible error in any of the proceedings on that score.
Can you address, because this is all under the prosecutorial misconduct, assignment of error. Can you address the usage of, or the discussion of 9 different experts that were not part of the proceedings in bolstering the state's experts that were part of the proceedings?
Right. Your Honor, first of all, in terms of the closing argument, I'll note that the appellant is only specifically assigned as error the Washington Post article issue. But beyond that, I think when we look at the context of what the rebuttal prosecutor was saying in this case, he was saying that the treatment team at Children's Hospital were treating JF as if this were an acute instance of abuse. The interventions that they used, the urgency with which they put him on life support, et cetera, all indicated from the medical records that are actually in evidence, all indicated that they were unanimous in treating this as if it were an acute case of child abuse. And I understand that it could have been more artfully worded, but I'll note that there was no objection to that in this case. And I don't think, when you look at the context of the prosecutor's comments, I don't think that there was any plain error in their admission. In terms of the Castile giving what defense counsel referred to as a expert testimony, I think this is clearly a case that's decided under Evidence Rule 701. The Graham and the DR cases from the Supreme Court. As long as the testimony is rationally based on the perception of the witness and helpful to the prior fact to determine a fact at issue, there's no problem in Mr. Castile commenting about the lack of affect on the part of the defendant when confronted with when told about the tragedy that had occurred.
His testimony was simply on the defendant's demeanor at the time.
Yes, Your Honor.
And I also looked at the cross-examination on that,
Right.
And I'm sure that you would probably agree that it was a good job with regard to parsing through any issues
I
there.
agree with that, Judge. I think that any problems with giving the testimony was fully explored on cross-examination, and there was no request for any kind of limiting instruction, no objection to the testimony. So again, I think there's no plain error in this case. Unless the panel has questions, I think I'll rest on my brief at this point.
Thank you.
Thank you very much.
Mr. Crusher, you have 3 minutes.
Thank you, Your Honor. Just a few record citations to respond to the panel's questions, both of me and Mr. Sauter. In the rebuttal closing argument, the prosecutor said he didn't cut out Dr. Weems not because he didn't like her opinion, but because she did not know the cause of Jace Fitzhugh's death, and she relied on the recut slides. That's pages 2138 to 2140. The vouching, where the prosecutor is vouching for Dr. Dean, she says she knows what she's talking about. She's been doing her job for 35 years. She's not in the business of making extra money by helping mounts, and is not on anybody's team. That refers to the whole team mounts theme that was raised both in the initial closing and in the rebuttal. That was page 2159. The citations to the other doctors, Dr. Jacobs, Amy Holden, Meredith Drake, Lee Hyung, Bernadette Koch, Margaret Kerr, Julie Guerin, Maya Lynn Dewan, was pages 2166 to 2167. He didn't call them because they would make the trial too long. The Washington Post issue was raised in cross-examination of Dr. Chundru. The prosecutor said, "You're not worried about the guy that came all the way from Washington, D.C., the Washington Post, to cover this story and cover your testimony?" That's volume 27, page 1731. And then in closing, there's an objection in the argument about that.
Why is that improper now? My understanding is that this particular expert did not charge any money
Correct.
to testify, but there was a reporter that was interested in covering the case. So why is that improper for the prosecutor to point out potential interest that expert might have had?
Well, it's not evidence, first of all. The fact that the expert is waiving his fee, he did say that. And
That was a question that was asked, right, on cross?
yes.
Okay.
And then they ask him about whether his opinion is being affected by the press involvement.
That was a question on cross.
That was the question on cross. That was 1731.
Okay.
And it just built for the statement in closing that defense counsel did object to on 2148, 2149, that it allowed the prosecutor just to argue to the jury that Dr. Chundru's beliefs or his opinion couldn't be trusted because there was a Washington Post reporter in the room. I think that I can't think of a it's extraneous. It doesn't relate to his actual veracity.
Were the questions on cross proper?
I don't think so,
Why not?
because he's addressing the presence of a person in the room who isn't a witness, who isn't anything. It's a suggestion that he has an ulterior motive.
But isn't that proper for cross-examination?
I don't think so, Your Honor. I think if there's an evidentiary basis for it, right. Email from the reporter with Dr. Chundru that says, oh, we're going to make the prosecutor look bad. I'm going to come cover your testimony. Sure. But just the presence of a member of the media, there was not even an article by this guy. He just had, in fact, he wasn't even there to write the article that he ultimately wrote. He was there looking at issues of, I forget exactly how he phrased it, it's been a long time since I talked to that reporter, on a whole different subject. I can't tell you exactly what he was there for. It had ended up turning into the article in the Washington Post about injustice in Ohio courts and how they treated Mr. Mounts, but that wasn't why he was there. He was not, I don't think, had any connection to the defense at that time. So I think that was improper. It's like arguing that today's Monday, so the defense must be guilty. It's a completely extraneous fact.
You actually are at your time,
Oh,
unless
okay.
my
Thank you,
colleagues
Your Honor.
have additional questions. Okay, great. Thank you so much. Thank you both for your arguments today. The case is submitted, and we will issue a timely decision. Thank you. The next case is the OLB Group, Inc. versus Blue Square Resolutions et al. Mr. Griffin, you'll be arguing?
Yes, Your Honor.
Would you like to reserve any time for rebuttal?
4 minutes, please.
4 minutes, okay.
Just some housekeeping. If you notice, these sunglasses have some pretty severe cataracts, and so that's why I'm wearing these.
Okay, sure.
I didn't think you were auditioning for the Blues Brothers. But
Yeah, I just did a trial in Boston. In fact, the district judge had the lights down for me and things like that. They just crept up, so I didn't anticipate this, but I wanted you to know that this
Thank
is
you.
necessary.
Sure.
Surgery's in July. I have a very hard time reading under the circumstances. So,
Take your time.
you ready?
Ready when you are.
All right. This case is a contract case, clearly. We tried it a year ago in front of Judge Cross. We're not contesting the liability as to the breach of contract. As set forth in the briefs, it's a relatively straightforward contract. One party boards merchants, the other party gets a residual from the boarding of the merchants. The uncontested evidence that I think is very important for me to lay the foundation before I get into a little bit of analysis is that my client entered into the contract with the plaintiff appellee's client in 2014. In 2016, we assigned that contract to a company called AMS. We assigned that contract with 50 other contracts. Out of the 50 contracts that were assigned, and they were freely assignable contracts, nobody ever contested that. Out of the 50 contracts that were assigned to AMS in 2016, The only one apparently that wasn't paid on is the contract that we're here for today. And so I set that framework for your honors because I think it's important to remember how this transaction wound up in the courtroom.
And I don't know if this is going to sound redundant to you, but I'm going to ask it. Would you characterize the transaction in 16 as an assignment?
Yeah, I would have characterized it as assignment. Under the, there was actually a contract breach claim as part of their original cause of action claiming an improper assignment or improper transfer due to lack of consent. On cross-examination of Patrick Smith, the plaintiff's expert, the plaintiff's witness at the trial, he confirmed that the transfer was proper and that these contracts are, quote, assigned all the time, freely assignable. In fact, the reason we were in Hamilton County is because of the company called Vantiv, which is a large credit card processor, and this contract was lifted from a prior Vantiv contract, even though Vantiv wasn't a party to this case. The people in this industry use boilerplate contracts from time to time, but they're enforceable.
So that's why it had Hamilton County in.
That's why it had Hamilton County, despite the fact that the plaintiff was in Brooklyn and the defendant was in Orange County. And I'm from Denver, my partner's from Philadelphia. So the only person that was actually from Hamilton County in this entire case is opposing counsel, Mr. O'Brien. Judge Cross actually inquired about that. So we have this transfer, and we're not contesting liability that it wasn't paid and that money didn't get to the plaintiff. What we're contesting on appeal primarily, even though it's not our first argument, is the calculation of the damages. And what I'm asking this court for is to vacate the judgment and remand it to Judge Cross for a proper accounting, and I'll explain that. The marketing agreement clearly provides, it's uncontested, that there's a 180-day Section 7 look back. Judge Cross found in the findings of fact that Section 7 applies in paragraphs 34 and 36. Judge Cross notes in the underlying opinion that there was no Section 7 notice given between 2014 and 2017.
Isn't that as to the reports and not as to non-payment?
Absolutely not. If you look at the record and if you look at our reply brief, I cross-examined Patrick Smith and said, the Section 7 notice deals with money, correct? He says, correct. I said, that means missed payments, correct? Correct. Now, in the appellee brief, it says, oh, this is only about transactional issues that aren't relevant to the underlying transaction. Not true. It's a misstatement. 7 out of 33 citations to the record are misstatements in appellee's brief. That's one of them.
So this is who testified? This is their
Patrick Smith.
So Patrick Smith's interpretation of the contract.
Patrick Smith is the plaintiff
Right.
seeking to enforce the contract.
But the language of the contract seems to deal with reports and records
Well,
rather than of that section.
Well, how the contract is governed and how the parties operate under the contract is the relevant inquiry. No, the judge never found, the trial court judge never found that this contract only deals with technical reports or something along those lines. She found that Section 7 notice was required in order to trigger a payment or trigger some kind of claim. That was her findings in paragraphs 34 and 36. She also finds that there's no Section 7 notice after the February 2017 notice. So it begs the question to the court, how could she find the $258,000 number based on a Section 7 notice, based on payment, right? Not based on some kind of terminal error. The judge finds that the $258,000 March 2017 demand, she finds that that's a Section 7 notice.
Wasn't that the number that was on one of the reports?
That was a number on a demand letter from a lawyer.
But was it based on these reports?
No one knows, and that's what we've brought to the court's attention. There's no underlying testimony and there's no underlying documentation from First Data or otherwise that substantiates the $258,000. The $258,000 is on a late March 2017 demand letter from a third-party attorney.
I thought the demand letter was based on these reports.
Well, maybe it is, but there was no witness to talk about how the demand letter was calculated. There's no testimony to support the calculation of the demand letter. The only thing that the court would have been able to look at, presumably, would have been monthly reports that show how much money every single month was, due to a party based on the first data transaction.
Those were in evidence.
Those were not in evidence.
Those were not in evidence.
Right.
Okay.
So because they're not in evidence, the judge's calculation, from my perspective, becomes a little bit suspect.
It's based on a demand letter.
It's based on a demand letter, and she triggers the 180-day notice by citing to it in the findings of fact, and she cites the Schedule B. My scenario for this court, if as I would explain to my partner and to my client, is if this could go back on remand, and Judge Smith, we can find that there was a breach. We can find that there was money potentially due. We can find that the Section 7 demand letter from March 2017 is valid as a form of notice. But then we have to look back 180 days and calculate, pursuant to Section 7, what that dollar amount is. And what would happen if that were to occur is that Judge Cross would have to look at the record. She wouldn't be able to find any transactional history because it's not in evidence. So then she'd have to look.
Can I ask you a question?
Yes.
At the beginning, you said, I think, that you were conceding liability under the contract. Your brief raises a standing question.
Right.
Are you waiving that now?
I'm not waiving it. I'm just not. Well, the standing question doesn't get to whether or not there's liability as to breach of contract. That only gets to whether or not the parties had the right to bring the case in Hamilton County or the right to bring the case at all. So I would see the standing issue as something different from whether or not there was a breach of contract. If there's no standing, and the standing issue is relatively straightforward, is that there was an anti-assignment clause in the underlying contract, and Ohio courts will either enforce the anti-assignment clause or they won't. If the plaintiff's argument regarding the
to my first question as to whether this is an assignment.
That's a good question. And the appellee says that it's not, that it was an acquisition at an auction. Now, what I don't find in the appellee's brief, and what I didn't find at the time of the briefing of the findings of fact, conclusions of law, is where in Ohio does it say because there's an auction, the anti-assignment clause is invalid? It's not in the brief. There's no law. The only thing that's in the brief is that Mr. Burrell, my client, was aware of the auction, and so therefore the anti-assignment clause is waived. Well, I know it says that in the appellee's brief, but we point out in the reply brief that if you go to the record that that's not true. That's one of the 7 misstatements, the citations to the record, 7 out of 33, which we raise in our reply brief. So on the anti-assignment clause, my legal perspective is either Ohio is going to enforce it or it's not. And if it's not, and it's going to go on this auction theory,
Well,
then there should be
I think
some law.
again, there's 2 questions. One is it an assignment or not? And then secondly, if it is it going to be enforced?
Well, I think it's an assignment, and one of my closing argument themes was the tale of 2 assignments, because although we had the right to assign our contract to AMS, which we did along with 50 other contracts, there was no such right to assign the contract by the appellee. There was no such right. That's one of the barriers of our case.
So at the time of what you're characterizing as an assignment, was there already a debt?
At the time of the assignment? Well, there's a claim that no payments were made between October 2015 and present. The assignment was in 2016. And so the non-payment presumably would have started in October 15, although, other than Mr. Smith's testimony, there's no evidence in the record other than the October 2017 demand letter. And so, I think, and in the October 27 demand letter, it says that the payments are accruing at somewhere between $10,000 and $15,000 a month. If you take March 27...
Ultimately, there was a debt.
Pardon?
Your answer to that is yes, there was a debt, right?
For purposes of this argument, I'm agreeing that there was a debt now because that's what the court found. We presented evidence that the money was paid, but the evidence was not sufficient to persuade the court.
Can you go back to Judge Kinsley's question? I'm trying to understand. Your argument is that there was no standing. If we would agree with that, then what?
Then the case is the judgment is vacated.
Oh, okay. So we wouldn't go to damages.
We wouldn't go to damages.
Okay. I was just wondering why you were kind of skipping over that.
Well, I'm skipping over because it's only one case. It's like, there's an anti-assignment clause. There's a theory that there was an auction. The court, I only have 15 minutes. So I thought that the brief stood for itself on standing. On damages, I was just very particular about coming in today and saying you know, if Judge Cross takes the 2017 demand letter and she goes back 180 days at even $15,000 a month, which is what's in the demand letter, every month is $15,000, and she applies the Section 7 notice and doesn't just say that it applies, but then doesn't apply it. If she applies the Section 7 notice and she goes from March, and she goes back 6 months, even at $15,000 a month, it comes to a damage number that I think is appropriate under the evidence. I'd like to get next, if I could, to...
You actually are at your time if you want to reserve 4 minutes.
I'm at time, okay. Well, I'm just going to...
You can eat
I'll
into your
reserve 4.
rebuttal if you want.
Pardon?
You can eat into your rebuttal if you want.
Yeah, I'm going to eat 1 minute.
Okay.
Okay? On the attorney's fees issue, the second primary reason that I wanted to come today to talk about this one, request oral argument, and I started with this today, there was an assignment of a contract to AMS for consideration. AMS paid on 49 of those contracts. One of them it didn't. That's why we're here today. There's a breach of contract. I understand that. $258,000 was the damage amount. There's nothing in the record that would substantiate this finding of bad faith, where there was a willful, malicious plot or scheme to defraud the plaintiff. There was one contract that allegedly went unpaid that we found out about in March of 2017 after we assigned the portfolio to a third party. As we point out in our reply brief, if every time that there's an assignment of a contract and there's a non-payment, that triggers bad faith, then we're in a very dangerous precedent. There was no evidence before the underlying court as to any indication of bad faith. There was some testimony about $1 million pools, a Ferrari, many other things. I think that triggered various biases in the lower court to award these attorneys' fees, but they were never tied to the missed payments. $258,000 speculative damage. Was Mr. Burrell buying a $1 million pool with $258,000 or $5.7 million house with $258,000? Mr. Burrell testified that he acquired wealth prior to the AMS transfer. There was nothing in the record showing that this money went to Mr. Burrell and then to the pool. The money went to Mr. Burrell and then to a car. That Mr. Burrell was sending emails to his friends that he was going to, get one over on the plaintiff or anything along those lines. The bad faith finding, Mr. O'Connor says in his brief that it was not found willy-nilly. It was found willy-nilly. I implore the appellate court to go through the record, go through the brief. You will not find any of the facts that give rise to bad faith finding. And so for that reason, we ask that the bad faith finding be vacated as a matter of public policy and specifically because it lacks evidence in this case. How much time?
I'll give you 3 minutes.
Okay.
All right?
Thanks, but I do have a question that's not going to cut into his time. With regard to how bad faith was determined in this case, is there any case law that either supports that determination or undermines that determination?
Well, the case law that we cite sets forth what the basis to find bad faith would be in Ohio. And there are examples in those cases about what bad faith looks like. And specifically, what Your Honor will find in those cases is fraud, malicious, bad intent, things of that nature that show a motive to scheme. It is impossible for us to have assigned these contracts in 2016, a demand letter to show up in 2017, and for it to find bad faith that we freely assigned contracts to a third party, and the third party didn't pay on them. We're accepting responsibility for that at this time because we have to. But how can you have bad faith with a third-party non-payment? That's factually impossible unless you can develop some evidence to support it otherwise. That's my response.
Thank you.
Thank you.
Morning, Honors. May it please the Court. I'd like to start with talking about the first assignment of error that Judge Kinsley noted. I was a little surprised here to hear that they're not contesting liability on the breach of contract. I was expecting to have to tell you that they were trying to have their cake and eat it too, that they were trying to enforce a jury waiver, a forum selection clause, that they were counterclaiming under a contract and then saying that they weren't, that somehow my client wasn't entitled to enforce that contract. I think what we've heard today on appeal is that they're not contesting liability And so I believe, unless the court has any questions on that first assignment.
I mean, I thought he responded that they are still contesting standing, that they just didn't want to focus their argument on standing.
I hear I hear my friend say two different things.
Okay.
And if they are pressing forward and not waiving that first assignment of error, we referred in the brief to the Schofield case from 1992 from the 10th District. There was a case about an architecture firm that had the right to receive payment. The firm dissolved, and then the right to recover for a breach of that contract was passed along to the partners, the architects themselves.
Was there an anti-assignment clause in that case?
There was not.
Okay.
But to your point, in this case, there is the contract language that we've all referred to. However, this is not a case of materially changing the burden of the parties. None of us want to go out.
What does that matter if there's an anti-assignment clause?
Sure. So if you look at, for instance, the restatement of contracts, if you look at sections 317 and 322 of the restatement of contracts, what they'll say is that the right to assign a contract, you can't do that if it materially changes the burdens of the parties. And so none of us want to go out and hire Leonardo da Vinci to paint our kitchen and have him assign that, and we get stuck with Lenny Smith, who doesn't do as good of a job. In this case, performance of the contract had fully occurred, and so the only thing that was left was the right to recover damages in the event of non-payment.
Do you think that this anti-assignment clause covers that, or are you just asking us to ignore this language?
I'm not asking you to ignore the language. I think that if this was an instance in which Securus or OLB had gone out and tried to have a third party go out and knock on the doors of delis and pizza shops and sign up those places to use credit card processing, in that instance, that contractual provision would be enforceable.
So that's the obligations.
It's correct.
But what about rights? Rights to collect the residuals. That also seems to be included in this language.
The rights to collect the residuals, courts across the country, and the restatement tells us that if you have a contractual provision saying that you can't assign the right to collect damages, then in effect it's a liquidated damages, it's an unenforceable penalty, because all you're doing is preventing a party from recovering for services that are fully and completely already formed.
Okay, so that's your argument, is that we need to basically disregard that portion of the contractual language about.
Well, my argument is that's
Right.
what the trial court did, and I think this
Okay.
court should affirm.
Okay.
I don't think this court needs to review it at the outset.
If there's not standing for some reason, if we do decide to enforce the literal contractual language, what happens to your unjust enrichment claims?
Well, it proceeds, Your Honor, and that's, the court dismissed those as moot, finding at the Rule 41 motion in the proceedings below that the OLB group couldn't proceed on both a breach of contract and unjust enrichment claim. I think that's the right ruling. But if it turns out that OLB wasn't entitled to enforce this contract, this ISO agreement, then they certainly still have a right to pursue a claim for unjust enrichment, and I suppose the remedy would be to remand and let Judge Cross sort that out. As to I want to, Judge Zayas, talk about your question of, with regard to the third assignment of error, the assignment and was there already a debt? Absolutely. The payments stopped being made in October of 2015. The assignment happened after that. And so when the appellants receive a $30 million buyout, sell everything from their company, including the broom in the broom closet, knowing that they have a creditor and knowing that creditor has not been paid and doing nothing to pay my client, and that satisfies the statutory requirements under the Ohio Uniform Fraudulent Transfer Act. And so with regard to the third assignment of error, I think that completely resolves that matter.
Did they know, was there communication between your client and them about the non-payment status, or was this something that was slipping through the cracks? Do we have evidence on this point?
I think it's a little bit between, Your Honor. I would tell you, and I told the court below, that my clients, as it turns out, weren't the best debt collectors. Were they doing what I would have done, which was send an email every week and hounding it? No. But there was communications. There was this demand letter. I want to say it was Exhibit J in the trial court below. There were some of the other emails talking about it. And so it's not fair to say that there was silence, but it's also not as hasty as I would collect a debt.
Do you know the date of the demand letter?
Off the top of my head, I don't, Your Honor.
So Mr. Burrell was sued not for the breach of contract piece, but for the fraudulent transfer part, right?
That's correct.
And how is he personally liable for this fraudulent transfer? My understanding is that money went from Blue Square, an LLC, into another LLC that was not made a party.
Sure. So it was a shell of LLCs. The trial court record indicated that Mr. Burrell had LLCs for each one of his houses in Arizona and Corona del Mar for his business, his subsequent business. In fact, there was another one at SLB Ventures 1. And so when we look at the Ohio's adoption of the Uniform Fraudulent Transfer Act, we see that it's a remedial statute. We see that it's designed to empower a trial court to do equity. When you see someone that is transferring assets from a company with the effect of not paying a creditor, the trial court has broad power to do things like issue a disgorgement order, which is what happened here. And so when we look at that, when we think about it being a remedial statute, if we look at the revised code, section 1.11, we see that remedial statutes are designed to favor the plaintiff and empower the trial court to do whatever is necessary to correct the wrong.
But your complaint had accused Mr. Burrell of basically pocketing this money and I guess spending it on other things. But I guess my understanding of the trial testimony was that the money actually went into another corporation, SLB, right?
Sure. And so the trial testimony was, we said, well, where did you end up diverting that money into? I said, were you the 100% owner of Blue Square Resolutions? Yes. Were you the 100% owner of SLB Ventures? Yes. And what are your initials, Sabin L. Burrell? SLB.
So there's no need to bring in SLB as a defendant in this case?
We could in a future matter. As a matter of debt collection at the time of the lawsuit being filed, we didn't know SLB Ventures or SLB Ventures 1 existed. And theoretically, perhaps there is a separate cause of action against them. But it's up to the trial court in their discretion to allow the money to be traced wherever it flows once a fraudulent transfer has been established under the statute, Your Honor.
So the trial court instead of ordering just a judgment against Mr. Burrell is ordering Mr. Burrell to disgorge money out of another company.
That's correct.
And you're saying that that is proper under the trial court's equity power?
And under the statute that
Under the
provides
statute.
a broad set of remedies for the trial court to do whatever is necessary to remedy a fraudulent transfer.
Okay.
And when we think about that statutory language, I think that ties well with the fourth assignment of error with the attorney's fees. Of course, we review that on an abuse of discretion standard. Here, the trial court found bad faith. The trial court intently sat through a bench trial, found that a fraudulent transfer had occurred, found that bad faith had occurred, and so that was more than sufficient to justify an award of attorney's fees here. With regard to the second...
Is that kind of automatic? If you find a fraudulent transfer, then it justifies attorney fees?
I don't profess to tell or to think that a trial court always uniformly has to do something. I think that the trial court has broad discretion using its equitable powers to determine whether it's appropriate or not. And here, Judge Cross found that it was. With regard to the second assignment of error and the damages, I completely agree with Judge Kinsley that the plain language of the marketing agreement says that that provision that they cite to addresses reporting of errors. And so this is an instance of if the calculation, the monthly report that they get from this first data company was wrong, then they have a certain amount of time to correspond with one another and look at it, just as we all get our monthly bank statements and have a certain amount of time to go and tell our bank whether they counted my deposit correctly or not. And it doesn't refer to just simply recovering for damages for a breach of contract. It wasn't a statute of limitations provision in a contract.
Did your client's representative testify that he believed this provision also meant payment of money?
I can't recall that testimony. I will tell you that my client definitely testified at trial that he reviewed the statements monthly, that he had personal knowledge, that he had gone through and performed the calculations. And so when I heard my friend on the other side say that there was no testimony supporting this damages calculation by the trial court, that's simply incorrect. The trial court chose to believe Mr. Smith's testimony over Mr. Burrell's.
Was there evidence of the demand letter, where that figure came from?
Yes, when we, in the closing argument and other points when we were referring to it, it matched to the penny, is my recollection, another calculation that we looked at.
Did it come from the reports that are at issue in the Section 7, or do we not know this from the testimony?
Well, in what I'm trying to recall, Your Honor, there was an issue at trial of the testimony was that because there's so many transactions in this credit card industry, I believe Mr. Burrell himself said that the Excel spreadsheet that they get every month was hundreds of thousands of rows of each transaction, getting 7 cents here and what have you. And so at trial, we had offered a compilation of the monthly summaries of that. And Judge Cross said that she would have preferred to have the individual Excel spreadsheets with hundreds of thousands of that. And so we relied instead on Mr. Smith's testimony, which was based on his personal knowledge and his personal review. And under the manifest weight of the evidence standard, there was no miscarriage of justice here in the damages calculation. This is one where the trial court didn't wholly adopt my client's position, didn't give them the $600,000 that they were looking at. They said $257,000 had been proven, and that's what she entered. I'm sure I'm close to my time. Unless the court has any other questions, I'll ask you to affirm. Thank you.
Thank you. You have 3 minutes.
Yes, ma'am. Yes, Your Honor. Number one, Patrick Smith testified that the residual report is the money report, and that the debits and credits referenced in Section 7 referred to money. It's in our brief cited at our reply brief cited at page 9. Second question.
Wait. It refers to money.
Refers to money.
Not missed payments necessarily. Of course it refers to money.
Well, it refers to debits and credits. And so, you know, in the context of the cross-examination, and I didn't bring the entire record with me, but when I heard Mr. Smith say, oh, that Section 7 is just nothing, I was very specific on cross to say, no, that Section 7 regards to money, correct? Debits and credits, correct? When the judge found that the Section 7 should be adopted as a form of notice between these two parties, not between First Data and somebody else, she found, why would the lower court find that Section 7 notice was important if it didn't trigger the obligation to pay the money? She calls the $258,000 demand letter a Section 7 notice. She doesn't call it some other little thing that people talk about. She calls $258,000 demand from their client to ours a Section 7 notice. That means that that's how it's being treated by a matter of law.
Counsel, if there's no standing under the contract,
Yeah.
what happens to the unjust enrichment claims?
Well, if it's a contract claim, then unjust enrichment doesn't apply. So if you bring a claim for breach of contract and unjust enrichment, and breach of contract is your theory, then unjust enrichment doesn't apply. You can't plead in the alternative. So if you plead breach of contract and the anti-assignment provision is upheld, case is out. And when the judge dismissed unjust enrichment, she did that because they brought their claim not in equity but in law. That was a choice that they made. And so that's...
They had it on the alternative.
But then unjust enrichment was dismissed.
Right, and there was no cross appeal.
And there was no cross appeal. So that's the end of that from my perspective. I wanted to talk very quickly about this fraudulent transfer because I think Your Honors are onto a couple of things. One question I did want to answer. I think Your Honor, Ms. Kinsley, asked, well, do you know when the transfer was versus when the debt accrued? The transfer, when we transferred our contracts to AMS, was September 2016. The demand letter, the so-called Section 7 notice, was March 2017. So Mr. O'Connor is saying to the court, oh, we knew about this debt and transferred it away to the detriment of the plaintiff in order to steal his money. That's impossible under the trial court's record. If the contracts were transferred in September 2016 and the Section 7 demand letter was in March 2017, how could we have known about this so-called debt when the demand letter was 7 months after the transfer? That's really important when you're looking at what the rights and the obligations are, and specifically to the fraudulent transfer.
Counsel, wasn't there a testimony by your client that he thought that these bills were being paid?
That's correct. And he operated that way, and when he transferred to AMS, he expected that AMS was paying those bills. This March 2017 demand letter, he testified he never saw because it went to the new guys. Okay, so if we're required to pay under the Section 7 demand letter, then let's go back 180 days under Section 7, because that's what the judge calls it. Quickly on fraudulent conveyance. Tortured debacle judgment on this. The money from AMS on the sale, the transfer of the assets, goes to Blue Square, the defendant, and then is transferred to a wholly owned subsidiary, SLB Ventures, a successor in interest. That evidence is in the court, and it's in the findings of fact and conclusions of law. Mr. O'Connor could have taken discovery. He could have found out about SLB Ventures. He took Mr. Burrell's deposition, I think, 3 times. He could have asked him, where did the money go? What happened after the money came into Blue Square? Did it go to you? Did it go to SLB Ventures? Where did it go? He talks about the court has broad discretion to just find whatever it wants based on equity. Not true, not with any record, underlying record. If the transferee, in this case, Blue Square, was rendered insolvent at the time of the transfer, which it wasn't, then the money would have gone to SLB. SLB would be the transferee, the proper defendant. The fact that Mr. Burrell was tagged for this debt, we call it rough justice because it was, in my estimation. The fact that Mr. Burrell was tagged for this debt without a alter ego theory being proven or even raised is preposterous, frankly. It was disheartening. And then it went right to the bad faith award to Mr. Burrell, where he transferred the assets 9 months before the demand letter. We asked this court to vacate everything, but if it's going to hold on liability on Blue Acre, we'd ask for a remand on the 180-day and Schedule B calculations. Thank you.
Thank you. Thank you both for your arguments.
Okay,
this
appreciate
morning. We will take, the case is submitted, and we will issue a timely decision.
By the way, Your Honors, is that YouTube recorded, or is
Yes.
that just it?
It's
Live and that's it?
no, it's you can find it later.
Okay.
Yes.
Thank you.
Starting tomorrow, you'll be able to pull it up.
Thank you, Your Honor.
Okay?
Pleasure to be here, by the way.
Thank you.
Thank you.
The next case is State versus Hobel. My understanding is that the city and the county are going to split time.
Yes, Judge.
How much time?
The city will be going first. I believe I'll take 8 minutes.
Okay. You'll take the rest of it. I just wanted to make sure that you all were doing that. Just do it however you see fit. You have 15 minutes. And Mr. Duncan, would you like to reserve time for rebuttal?
Yes, Your Honor, if I could reserve 3 minutes, please.
3 minutes, absolutely.
May it please the court. Your Honors, we are here on vastly different cases that we've seen so far this morning. However, it's also a pretty unique criminal matter as well because, quite honestly, I think that there is, as reflected by the record here, we're dealing with a case that is primarily targeted towards the decisions of the trial court. Now, there was no objection made by the county, and there was what is likely going to be referred to as an objection by the city. However, the objection by the city in and of itself was in word only. There is a quite arduous process for the prosecutor to actually engage in any sort of objection with a sealing. That has to be in writing, that has to be given to the defense counsel in advance so that defense counsel can anticipate what the bases of those objections are. None of that was done in this case. And I think the record also reflects here that any objection that was made was essentially solicited by the trial court itself. Now, this case before the court here today seems like it is in a list of cases coming out of a specific trial court. And this is just the natural progression as well. And I will be addressing one case that was not mentioned in either briefs that this court did rule on, I believe, on the 3rd of May. And that would be State v. Afori, if I'm pronouncing that correct. Looks like that date of judgment on appeal did come out on May 3rd of 2023. We'll get there in a moment. However, again, we're not dealing with the typical appeal where the state is presenting its case, as ardently as it might, because quite frankly, from the record itself, I won't speak for the city or from the county, there was not much of an interest in actually opposing the sealing itself.
Counsel, I'm sympathetic to what you're saying in terms of the sandbagging aspects that you're describing when the government does not file something in writing in advance. But there's also case law that places the burden on the defendant to bring forward evidence to substantiate rehabilitation and to show why the defendant's privacy interest outweighs whatever it is that the government is going to assert. What evidence existed on the defendant's side of the equation in these cases?
Well, I want to start first with the interest weighing, because I think that's the easiest one to answer. I want to primarily focus on the rehabilitation. But to start first with the interest weighing, that is the interest of the state. And there was no interest of the state that was brought forward. That's reflected in the record. The word objection, there's no actual factual finding within that.
But what was the interest of the defendant, going back to Judge Kinsley's question, what evidence was presented about the defendant's interest? Because it seems like there was only attorney argument.
There was attorney argument, and while the appellant was not present in court, the evidence that was presented there, based on counsel testimony itself, was that
counsel cannot testify.
Well, while that might not be treated as evidence, again, we're not saying that the appellant was there in person or anything, but those are still reasons, not necessarily evidence that was given in argument.
The problem is that the case law states that the counsel's argument is not testimony, and this is specific to a sealing case.
Correct, and like I said, I mean, I'm not here to state that my client was there when he was clearly not. I did get permission from the court prior to the sealing that the presence of the appellant was waived at that point.
But
Again,
that's not the only type of evidence. I mean, you could present exhibits, you could present an affidavit.
Correct, and none were presented in this case. I mean,
Okay.
that is
Isn't that
clearly
that problematic though, based on the case law?
It is, however, I think the response that I would give to that is that there are no legitimate state interests. I mean, so it's a balancing factor. While yes,
But then
there-
doesn't that make the scale equal? I mean, looking at this in the best light for you and your client, that makes the interest equal. The government's put forth nothing, but then your client has put forth nothing. And the case law tells us that you have the burden to get over the hurdle, even ever so slightly. And without any evidence presented by the defense, that just resets to equal.
At the very least, with it being equal, again, there's no outweighing there. Again, I would refer back to the actual the transcript itself to list the sections. Now, while there is no evidence of testimony or affidavits or anything like that, the prosecutors as well as the court does have the record of my client that there was no such behavior or convictions since then. These are things that, regardless of any sort of testimony, are clearly there for the review of the court. Now, additionally, I mean, the lack of a record. I mean, there's only so much that can be done from a criminal defense standpoint. Part of what rehabilitation wants to show is that that person is no longer being brought in front of the court for any purpose whatsoever. And that's exactly what we have here. Now, while these cases are, related in some way, there's a violation of protection order and an assault here. And briefly on the violation of the protection order, again, for the record, this is prior to April 3rd of this year. We are still dealing with old law, probably one of the last cases that this court will hear before the legislature did, in fact, change that. But the primary thing that I would think that any court would want to see is that they're not seeing that defendant in front of that court or any other court whatsoever, that there's no additional convictions, whether it's the same victim or anyone else. That's exactly what
Assuming we
have.
agree with you that lack of criminality over a period of time is evidence of rehabilitation, how does that factor into the defendant's privacy interest when we get to the weighing?
So again, if the interests are entirely even with nothing being brought forth by the state, again, any bump ahead of that is sufficient to satisfy the defense burden to get over that weighing of interest there. And again, that battle seemed to have been against the court, which was putting forth those ideas of, there was a mention of whether or not the prosecuting witness was brought in, which the prosecuting witness was not. Those, at the end of the day, this is the state's case. This is not the trial court's case. So our argument would be that if that was not done, maybe the remedy would have been to continue the case instead of ruling on it right then and there. That was not done either. But ultimately, that is the responsibility of whatever the prosecuting authority would be, the county on the county's matter, the city on the city's matter. And in fact, there was a sealing that was granted that day for a 1999 case. So obviously, the court put some weight in something to allow that to be granted versus these to be not. And from
Does that have preclusive effect against these parties? Is that res judicata or something on these factors?
I don't think so. And by the case law itself, I believe it was out of the Clark case. I believe res judicata was raised after the fact, but it was not actually raised in the record. That was not raised here. That was not raised by the county. That was not raised by the city. So we'd argue that there is no res judicata argument that they can now bring at this point. But moving on from that.
I'm sorry, just so that I understand your argument. So you agree that it is the burden of the defendant to put forth some evidence on the factors that the court has to look at for sealing, correct?
Yes.
Okay. And are you saying that by virtue of just filing the sealing application and the judge determining that he's eligible because he hasn't had any other cases, was that evidence, that he didn't have any other cases, that he hadn't committed any further crimes? Would you consider that to be evidence that was brought forward?
I would, because more by the fact that it was not brought forward, and that is something that, again, is definitely more accessible to the prosecutor in the trial court, something that is reviewed right then and there.
So it wasn't really evidence, it was simply everybody in the room just seemed to agree that he qualified.
Correct. Eligibility was not disputed whatsoever.
Okay.
Now, I would say that based on the actual review of the transcript itself, now going through into the rehabilitation aspect here, rehabilitation, there's no question, there's a large amount of deference that the legislature gives to the trial court. But rehabilitation also requires actual findings to be made. Now, the fact that this was made on rehabilitation, again, as I argued in my brief, that was kind of just a buzzword that was used. Now, there was no actual findings of insufficient rehabilitation factually.
But there was no evidence of anything that he was doing. There was counsel argument, but as far as evidence, there was no evidence of anything that your client was doing, right?
As far as any future convictions?
Just anything that he was up to better himself.
Other than counsel argument?
Other than counsel argument. There was no affidavit, there were no exhibits, none of that.
That is correct, as well as there not being an opportunity to present that if the court was in fact concerned with that, or the non-presence of the prosecuting witness or anything of that nature.
But didn't the court find that your client was rehabilitated when it granted sealing in the drug possession case? It had to have.
Again, I don't know specifically what, but it had to have. That's exactly what is kind of floating around in this argument here that we can't actually pin down.
But my question is the simple fact that your client hadn't committed any further crimes, is that enough to show to show rehabilitation, evidence of rehabilitation?
I think the case law absolutely supports that, yes. Someone can, in fact, rehabilitate themselves. Concerning rehabilitation itself at a criminal level, that's primarily what the court wants to see, is that they're no longer seeing that.
So you're saying that could be it? That could be the only thing presented, which was in your case, the only thing presented was that he hadn't committed any further crimes. That was the only evidence.
As far as evidence, yes, and that is more than sufficient as supported by the case law.
Well, don't we know that your client pled guilty to the underlying offenses, and doesn't case law tell us to take that into consideration?
It does. I mean, this was not a contested, this was not a finding by a trial. Again, and thank you, the plea that was done in both these cases, that's admitting guilt at the time of the actual conviction. I think that right then in and of itself is implicitly evidence as well of rehabilitation, where taking responsibility, pleading guilty, that as well as any lack of criminal record history since then, both are more than sufficient in and of themselves, but together definitely get over a threshold of nothing on the other side presented to combat that. So again, I don't think there's any sort of issue whatsoever with the initial argument of weighing interest there.
And you are at your time if you want to reserve 3 minutes.
I would reserve 3 minutes.
Okay, great.
I do have one question. Counsel, I don't know if you know the answer to this. Do you know if there's any case law out there that speaks to, and I'm talking about factor E, weighing the interest of the applicant and having the records pertaining to applicant's conviction sealed against the legitimate government interest of any. Do you know if there's any case law out there that speaks to that there is sort of a general interest in having it sealed that's presumed, there's like a threshold already presumed, when the person's filing it, that there's some benefit in not having that and having that charge sealed?
I believe there is, Your Honor. I can address that in rebuttal once I have a chance to review.
Okay.
But I do believe there are multiple cases directly on point for that.
In other words, before we even get to anything that the applicant will present, is that there is already some presumption, some belief that there's an interest in having a conviction sealed.
Yes, I believe, Your Honor, there is.
Okay.
I just asked to
All right.
readdress
Thank
the
you.
court.
Thank you.
Morning, Your Honors.
Good morning.
May it please the court. As you're aware, the standard that we're here for today is an abuse of discretion as to whether the trial court abused its discretion when it denied Mr. Hobel's applications for expungement. I think it was touched on extensively in Mr. Duncan's portion up here. The burden for this is on the applicant to present some evidence, specifically in this case, of the rehabilitation, and that the applicant's interests outweigh the government's interests in maintaining those records.
What was the government's interest?
The government's interest in this, Judge, just the state's interest in having the information present to it in the event that more of these charges come about. It goes to the protection of society, the protection of the people, so we can see if people are repeat offenders, if they happen to have a number of these charges dismissed or something. It's all very valuable information.
Was that presented by the government as an interest?
I don't believe it was in this case.
So I'm going to ask sort of a similar question.
Mm-hmm.
Is there a case law out there that speaks to that as being sort of like that beginning threshold of interest that the government walks into in the sealing, in a petition for sealing?
Not to my knowledge. As soon as you asked him, I wish I'd had that, but.
Okay.
So.
And is that interest that you just identified general, or is it particularized to Mr. Hobel?
I would say that it's particularized to these types of charges, the violating of protection orders, the assault charges, which was a domestic violence when it began. I would not sure I'd be making the same argument if it were a possession of a drug paraphernalia or something like that, but specifically crimes against other members of society, where you're able to look back and see someone's history if this is a pattern of behavior or not.
So that would always be the state's interest for these types of crimes?
At least one of them, yes. I believe that would be the main
Even
one.
though the legislature has said that they can be sealed?
Correct.
Okay.
That's on the legislature, but that would be our argument for these kinds of crimes.
And I guess, what I'm kind of interested in here is, I looked at the application that was filed. It was simply a form, I guess, that the court has that was filled out and filed, and there were no exhibits attached or separately filed. It was just counsel argument. But I believe the argument today was saying, well, there is evidence besides counsel's argument. The evidence is that he didn't commit any other crimes, and he admitted his guilt to the crimes that he did commit. How is that not enough? And when the state presents absolutely nothing, and actually the state didn't object, the city objected.
Yes, and I will concede did not file an objection.
Didn't explain the objection, right?
Also correct.
Okay. Yeah.
One thing I want to point out, if I recall correctly, on the city's violating protection order, I believe it was a no contest plea, not a guilty plea, which is not actually an admission of guilt.
Okay.
The not having the other charges since then, while I'm not going to argue that that's a bad thing. Obviously, that's what we want from people. But again, I don't believe that's actually evidence in the record. There was no form of documentation. That would, again, only go to argument from counsel. That was never verified. I don't know. I haven't ran his record since this. I'm not sure if that's the case.
It was just kind of assumed, I guess, based on the fact that the judge did inexplicably seal one of the cases. We don't know why. And nobody objected to the sealing. So we assume he hadn't been committing more crimes.
Right.
Okay.
And kind of get into these two as to why, under the rehabilitation aspect, why these two were not. Several of the factors that the court can look at when they are determining rehabilitation are the facts and circumstances of surrounding the crimes. The other one is from 1999, significantly before these cases. These two cases are both, well, the domestic violence, which became an assault, is a crime of violence, and it occurred within 1 year of the violating protection order. They both contained the same victim. The court really emphasized the time period, the nature of the charges, and the same victim aspect when determining the facts and circumstances surrounding these cases. And
So are you saying that an individual could be rehabilitated as to certain crimes because of the nature of the crimes, but not rehabilitated as to other crimes because of the nature of those crimes?
I think it goes to the level, the seriousness aspect of the kinds of crimes. And again, I think a big portion here is, I think the 99 was 17 years or so before picking up these cases.
But if they're eligible to be sealed, they're eligible. I mean, you're just looking at rehabilitation. So clearly they're eligible to be sealed, but you're saying that when we look at rehabilitation, we have to look at the type of crime to determine if they're rehabilitated?
That appears to be what the trial court did here.
Yes. Is that an abuse of discretion?
I don't believe it is. I believe, again, I think it's under State v. Brooks, when the trial court makes these types of decisions, the reviewing courts are supposed to give great deference to the trial court and how it makes these decisions.
I want to go back to the lack of criminality since 2017. When a defendant files to seal their criminal record, isn't there some kind of eligibility evaluation done? And if the person has, for example, a pending criminal charge, that would show up and the person would be deemed not eligible. So there is some kind of screening that occurs that would verify if there's ongoing criminal behavior.
That's correct. And we do get that information on our the reports that we get from the, I think it's the probation department that does the expungement reports.
So you would know that, the court would know that, defense counsel would know that?
Yes.
And none of that came to light in this case?
Correct.
So can we just make the assumption then that that is evidence of the fact that he hadn't committed any other crimes?
But the background check done by the people that did the...
I mean, it's just the fact that nobody raised it below. You're telling me that there was no evidence presented on that issue. There was nothing filed, but can we just assume because nobody raised that issue that, in fact, that is true?
I would argue that evidence has to be some sort of put forth beyond just the argument of counsel.
Okay.
If he had brought in...
Does he need a certified copy of his record?
Maybe something like that would be
Okay.
an example of evidence that he could have brought in, showing the end of the period.
Okay.
Could a person mark that probation report as an exhibit, for example?
I think if you had the probation officer come in and testify about what they did and kind of do that to authenticate the document, I don't see why you wouldn't be able to.
Or get the prosecutor. So you're telling me that the prosecutor would get the information and would see, okay, this person's eligible when the case is called?
Correct.
So the defense counsel could get the prosecutor to stipulate that he's eligible?
Yeah, that would
Okay.
be another option.
Okay.
And then another thing that goes on to the rehabilitation is a cessation or continuation of criminal behavior. I just want to briefly point out that the court in this case did note the closeness in time, meaning the continuation of the criminal behavior with the same victim as a concern as to why it determined that Mr. Hobel was not rehabilitated. And moving on to the weighing of interests and having these records sealed, again, it's the applicant that has the burden to demonstrate this. And the government, as mentioned before, did not make the argument that I just made, did not put forth any evidence for the governmental interests, but as mentioned by the court, that leaves it as an even scale. There is no outweighing of interests at that point.
So you would say it's even in this case? The judge said there was an outweighing.
He did.
And you would say that was probably wrong, it's more that it's even.
I don't see that the state presented anything to outweigh the defendant's interests.
So the whole case would then turn on the rehabilitation finding?
Based on what we have in the record, yeah.
Okay.
Yes. And at that point, unless there are any more questions, I would rest on my brief.
Okay, thank you. You have about 6.5 minutes.
Your Honors, may it please the court again. This court has addressed the question of a defendant's interest in having a conviction seal in State versus RS 2022 Ohio 1108. It's not quite a presumption, but there is a recognized privacy interest that the defendant has in having his record sealed. In this case, I think the court has a good handle on the state of the record. I think that in terms of the 1999 conviction that was sealed, I think that the court does have to consider the severity of the offense in determining how much rehabilitation needs to be shown. In this case, I think it would be simple in terms of rehabilitation for the defendant to have secured a copy of his criminal record from the state and submitted it as an exhibit.
So when you say severity, what does that mean?
Well, I think the 1999 offense, from what my reading of the transcript was a minor misdemeanor substance abuse, weed ticket, I guess, to be colloquial. Okay. And the other two convictions, first of all, were much later, and they also involved offenses of violence. So I think it's rational, and we're talking about an abuse of discretion standard here. I think it's rational.
When you say severity, you're talking about that it's inclusive of the nature,
exactly.
What I would call the nature.
Exactly.
I think you understand what I mean by that.
Exactly. And I think that would, under an abuse of discretion standard, it would be rational for a court to determine more of a showing of rehabilitation with respect to an assault or a domestic violence than they would for a weed ticket.
Do you have any case law to support that?
Well, it's statutory, Your Honor. The first thing the court is to consider is the nature of the offense. So I would just argue that under the plain language of the statute that would encompass that inquiry.
You don't think that a period of time is enough to show, of no further violent acts is not enough?
I think it could, Judge. It just depends on but what we have to keep in mind is that it's under an abuse of discretion standard. So, you could make the argument that it could be sufficient, but you can also make the argument that it wasn't entirely unconscionable or arbitrary for the court in this case to find that it wasn't sufficient. Okay. So I think that's what we're left with.
Right.
Unless there are any questions, I'll ask the court to affirm the judgment.
Thank you.
Thank you.
Mr. Duncan, you have 3 minutes.
First and foremost, to address the question that is left on the table here, I think the baseline is addressed in Gaines v. Rossi, which is out of the, State XRL Gaines v. Rossi out of the Supreme Court, stating that the statutes governing sealings are remedial in nature and must be liberally construed to promote their purposes. We also do have State v. MD out of the 8th District, while not binding on this, but the legislature recognizing that people make mistakes, but that afterwards they regret their conduct and are older, wiser, and sadder. The enactment of subsequent statutes regarding the sealing is in a way a manifestation of the traditional Western civilizations of concepts in punishment, atonement, and forgiveness. That's quoting both State v. Body, also out of the 8th, and State v. Hilbert, also out of the 8th. Those were both, all three of those were addressed by this court in the previous case.
Counsel, what about this concept that rehabilitation is offense-specific and that a person can be rehabilitated from one thing and not necessarily another?
I think that drives specifically at the abuse of discretion. I really believe that that is the dangerous idea, as we've seen in previous cases of judges maybe having a blanket rule of not sealing cases that originally were brought as a domestic violence. That is not what the conviction was. By law, regardless of what it was originally brought as, that was not the conviction. And I think it runs dangerous while at one point, we want to have discretion in the trial courts and not meddle in their business, but at the other time we want to make sure that there are not blanket rules that whenever domestic violence is used, that's a buzzword for a judge to automatically rubber stamp something and say that is not something I'm going to entertain. And I would like to point out specifically these two separate cases. I mean, one is with the city, one is with the state. The court has the ability to treat these differently. Now, we understand that one was shortly after the other, first having the assault and then a violation of protection order. But the time from that last offense, I think that the court should very much consider the weight of that evidence that might treat these two sealings differently. And again, I will reiterate that this is under the old law prior to there being now, I believe, a prohibition on this exact one. That I think that also safeguards this court into creating possibly a unwanted precedent, because the legislature has already ruled that is how they would prefer to go forward in the future. That is not something that this court would have to consider. And unless there are any other questions by this court, we would rest on brief.
Thank you. Thank you.
Thank you,
Thank
Your
you all for your arguments today. The case is now submitted, and we will issue a timely decision.
Thank you.
Have a good rest of your morning. Okay. Our final case today is State versus Sannon. My understanding is Ms. Peters, you're going to be arguing today. Would you like to reserve rebuttal?
4 minutes, please.
4 minutes. Okay. Whenever you're ready.
Good morning, Your Honors. May it please the court. My name is Laura Peters, and along with Sarah Nelson, we represent the appellant Michael Sannon. As this court is well aware, this case involves a shooting following a gender reveal party. The record is extensive, the briefs are lengthy. So it is my plan to discuss mainly assignments of error 1, 6, and 2. But the other assignments of error will probably weave in and out a little bit as well.
And remind us what those are, just briefly.
The first assignment of error is concerning the motion for judgment of acquittal.
Okay.
The sixth assignment of error is the confrontation issue.
Okay.
And the second assignment of error is the Batson challenge.
Thank you.
Okay. As I said, this was involved the shooting after following a gender reveal party. There were a number of people inside the house watching a movie when two shooters came in and sprayed bullets. That's not disputed. What is disputed in this case, though, is who the two shooters were. Now, the evidence in this case is very weak as regard to Mr. Sannon's, Michael's, involvement in this shooting. What we know from the testimony is that there was a plan to murder Cheyenne, and that plan was hatched initially between Rashawn Bishop and Robert Howard, AKA Geezy. And as part of that plan, Rashawn contacted his cousin, Vandell Slade, in Columbus. Vandell Slade, in turn, connected with James Eccles. The two of them come down from Columbus to Cincinnati on July 7th, and along with Geezy and Rashawn, those two surveil the Capstan residence, which is where Cheyenne was living at the time. Michael's not there. He's in Lexington, Kentucky. So he has no knowledge. There's nothing in the evidence that suggests that he was a part of the planning or anything in this case. Following the surveillance, GPS data with regard to James Eccles' cell phone and Google account, as well as Vandell Slade's cell phone, have them going to Lexington, Kentucky, and there is some Facebook exchange between James Eccles and Michael. But from there, any technology detail on Michael is absent until July 9th at 10:30 p.m. So there is none of the victims in this case who were shot or who were present at the shooting can identify the shooters. According to them, two shooters came in wearing hoodies. They can't identify them. There is no physical evidence that ties Michael to this.
This is witness testimony that's going to tie him to it, right?
It's testimony,
Not
circumstantial
victim
evidence from testimony, yes.
Yeah, trial witnesses, I mean, there's no forensics, there's no technology. There's witnesses who testified at trial that he was involved, right?
Rashawn Bishop, yes, who
One person?
was the planner of this event, ties Michael to it. And then Kevin Barton says he was there, but he also denies having much knowledge about this. He was there after the shooting.
Burning clothes in a barbecue, right?
Well, that's kind of interesting, Your Honor, because in the testimony, this burning the clothes never came up in any of the initial interviews with the detective or Agent Hageman. And again, the witnesses at Capstan, from the victim testimony from Cheyenne, from Brian, they say that the shooters were wearing hoodies. According to Rashawn, James Eccles said they put tight shirts over their head, and then they burned the shirts.
Doesn't Deborah also place Sanan at the after event?
She does. So this is afterwards. Again, there's nothing that actually ties Michael directly to the shooting. He doesn't participate in any of the surveillance. So, and what do we know? The jury in this case found Michael not guilty of 20 of the 21 counts he went to trial on. And he was found not guilty of every single firearm specification. So the state proceeded on a principal offender only. There was no aiding and abetting, no complicity instruction given. This verdict, and I understand the case law about inconsistent verdicts involving the separate charges, but the one count 6, is inconsistent in itself because of the specification is inconsistent. Directly on point is State versus Koss, where the Ohio Supreme Court reversed a conviction when the jury found that the defendant did not possess a firearm, and yet the cause of death was a single gunshot to the head. So they remanded the case for a new trial on the voluntary manslaughter offense only, and instructed that the firearm specification could not.
How was the jury instructed on attempted murder in this case? Did the instructions include firearms as a part of the attempt?
I don't recall at this time. I will check. But I believe it was probably the standard OJI instruction was given, from my recollection.
So it's possible, divorcing our intellectual inquiry about the elements of attempted murder from the facts of this case, it's possible that the jury thought that Sinan committed an attempted murder without shooting Miss Willis.
I disagree, because he was also found not guilty of a felonious assault. He was found not guilty of the burglary charge, aggravated burglary, which indicates to the jury he may not have even been there. So, and the fact that this was, I mean, I don't think we can divorce the fact that the only allegation, the only means that these offenses were committed was with the use of a firearm. And that the jury finding that he didn't have a firearm negates him from having committed an attempted murder.
So we are looking basically at inconsistent verdicts here, right?
In this limited circumstance between the firearm specification and on the count 6.
We would have to say this doesn't make any sense, right?
Well, correct, and it doesn't make any sense, Your Honor, and that's why in the Cost case they recognized that. The Ohio Supreme Court said, this is so inconsistent that it can't stand, and it went back for a new trial.
But how do you deal with the fact that Cost has been kind of determined to have limited precedential value by other courts and really hasn't been? I mean, I feel like the case law just seems to have gone in a completely different direction when we're looking at sufficiency, and we don't look at inconsistent verdicts now.
I do agree with Your Honor that the case law is different. That it shies away from Cost and kind of limits it to its facts. But then that's why the facts of Cost are very similar to what happened here. The only means of which anybody was injured was through a gunshot. Cheyenne was shot. So that's the basis of the attempted murder, and he didn't have a gun. Now, I mean, there was allegations that there could have been other people who were the shooters. I mean, other than Michael. I mean, but I understand in the sufficiency, it's just. And the point of a criminal rule 29C is if a defect comes to light after the fact. And the fact that there really is no evidence tying him or showing that he had a gun, and that there's no evidence. I mean, Rashawn Bishop said that they left at the same time, but it doesn't mean that Michael actually went with them. He came back with them.
But you're saying there's no evidence. I understand. Didn't somebody testify he was there and he was one of the shooters? Or are you saying there's no witness that testified to that?
Rashawn Bishop wasn't there at the site, and so the only two people alleged to be at the site other than the witnesses, I mean the victims, when I'm talking about those victim witnesses like Cheyenne and Brian, was Vandell Slade and James Eccles. No, neither one of them testified. Okay. So there was no, what I'm saying, there's no eyewitness testimony that places him at Capstan.
Understood.
All Rashawn Bishop can say is, they left my house, they came back.
Okay.
And that he had this plan with his cousin. And his cousin, we know, contacted Eccles, and they were there, they connect.
Isn't it possible that the jury, based on the evidence, felt that Sinan was involved in some way, looking at it that, yes, the evidence is fairly flimsy and not specific about what he did, and that they reached some kind of compromise looking at the charges and landed at attempted murder. And the case law says that they're allowed to do that, and that our role is very limited in looking at these kind of inconsistencies because juries are allowed to be lenient and they're allowed to reach these kind of compromises to come to unanimity. So how do we look inside the jury room to decide what they did?
Well, we know what the jury did with the gun specs, and we know what they did with all the other counts. And we also know that the jury was not instructed on any type of complicity or aiding and abetting. So you can't, so as far as that, then that would be against how the court instructed them, and there's no evidence that he did anything to aid or abet. Again, he wasn't present when they were doing the surveillance. He wasn't present when the conversations were being had between Rashawn Bishop and Robert Howard, a.k.a. Geezy. He wasn't there. So that's where the evidence is insufficient to support any alternative theory. The state went on principal offender. And again, the evidence is lacking to show that he was at Capstan and the jury said he didn't have a gun in his hand. So there's no way he could have committed an attempted murder on Cheyenne when we know the conduct that was the attempted murder was that she was shot.
And you are at your time.
I know it's time, so.
You still have 4 minutes for
Okay.
rebuttal, though.
Thank you, Your Honor.
Ms. Loud.
Morning, Your Honors.
Morning.
Please support Ms. Nelson.
On the sufficiency and the weight argument, yes, Sinan's phone was dark for 24 hours, but there was a lot of other evidence that connected him to the crime and that the jury could make inferences from to show his participation in the crime, his location, his purpose. On State v. Costs, this court just a little over 2 weeks ago again affirmed that it is factually distinct. It's looked at on its facts alone. That in Costs there was not a second perpetrator. It had to do with voluntary manslaughter, and I just think that limitation of it continues today. In the brief, there was a lot of discussion saying the defense felt that Rashawn Bishop and Deborah Bishop's testimony should be disregarded completely, and they lied about everything. But there was a lot in there that the defense does not contest about what their testimony. Rashawn, there was no problem with the fact that Rashawn said, yes, he had this relationship, took a loan, decided, didn't want to pay it back, and the solution was to have Cheyenne shot. They're not contesting, but he called his cousin, Vandal Slade in Columbus. Slade then said, I'm going to bring 2 people to commit this. There was Slade's, any of the testimony about Eccles, Slade, Robert Howard, or Barton, that wasn't contested. Now, in terms of what cellular data and social media was in the evidence that's not contested by the defense, the context of his communications with Eccles, he did not contest that he had a strong association with Eccles shown by Facebook photographs, Facebook messaging, Facebook communications. And then on the day that the shooting occurred, when the surveillance was done, earlier in the day, Eccles was texting with Sinan and getting responses from him. And these texts, it's when Eccles had said, we're going to thug it up, and a few other things, bring your thing, being gun. And Sinan did respond, the equivalent of right to these, showing he was in constant communication with him. You have the discussion, obviously, about going to Kentucky, Sinan's phone saying, yes, here's where I am. We're getting close. Okay, we're here. Okay. And you can see he was picked up. Eccles' phone then goes back to Cincinnati, to Bishop's house, to Capstan, back to Bishop's house.
So at that point, Sinan's phone, I guess, must have been turned off or something, or?
Yes.
Okay.
I don't know if
We don't, there's no evidence of where that phone went.
Yes,
Okay.
went dark. I don't know what, until the night afterwards, like 24 hours after the shooting. So, but you still have this, you can infer, the jury could infer that he was picked up in Lexington, was in the car with Eccles and with Slade, and went back to these locations.
Doesn't the jury's verdict suggest that they questioned some, if not all, of this?
If they had found him completely acquitted him, yes, but they didn't. And the verdict doesn't have to be rationally consistent. They do have the right to make a compromise verdict. There was enough. They did find him guilty of attempted murder. So, yes, all of the acquittals are there. But
They don't make a lot of sense.
They didn't, yes. And compromise verdicts are just very common. And I think it's obvious that's what happened in this case. You had Roshan Bishop saying Sinan was there right before they left, that they had discussed and gone. You have Deborah Bishop saying Sinan was there with Eccles before they left. But the one other thing you also have is Slade called Bishop when they were at the house on Capstan and said, Eccles and Sinan are walking in front of the house. They told me the front door's open. They told me there are a lot of people inside. So that is another connection. He was there.
Counsel, can you address the missing cell phone and Bishop's testimony that if this missing phone surfaced, and I'm paraphrasing, Sinan essentially would go free?
Yes. For 5 years, there was no discussion about a missing cell phone. During trial, yes, Bishop said he called his wife. It seemed to be he was boasting about things with her. When he was asked more on cross-examination, he said, the reason I thought it would make them go free was because there was missing evidence, and they could use it as a loophole or a technicality to get off. And that's really the farthest he went with it. And as I said, he even said, I've had a lot of years to sit here and think about it. And that's when he came up with it, was, say, close to 5 years after the shooting.
Do we know anything as to why he identified Sinan in particular as the person who would go free and not Eccles as well?
No. No. I don't know. You know, there was, it's not going to be in the record for this case. Well, it is. It's in the transcript that Eccles had put a threat against Bishop, made threats saying he wanted to kill Deborah Bishop. There was a lot of evidence of that, and I don't know if, make my own inference.
Personal conflict.
Yeah, and that phone of Bishop's wouldn't do anything to help Eccles' situation.
That's helpful. Thank you.
Okay. And Kevin Bishop, you know, he did not specifically identify Sinan as being at the bishop's house afterwards, but he did keep describing a dark-skinned Haitian man with this, you know, lazy eye, unique eye, whatever, however you describe it, as being there afterwards. Well, yes, as being there afterwards, and took part in the burning of the clothes. And no, he didn't know his name, and he would not say that it was Sinan. He continually, no matter how much the prosecutor asked, said, I can't say it was him. But that's still evidence. And one of the things about, on the sufficiency and the weight, I mean, there's no way to get around. Sinan had a very, very unique appearance. And everyone that saw him described it, brought it up. All of this was corroborated by, you've got Bishop, Bishop's wife, Barton, the police officers, and his photograph is in the evidence that for you to look at. I know Ms. Peters didn't have time, but I think she said she wanted to comment on the sixth assignment of error, which was about the Zoom call. I looked up all of the cases cited in their brief and their reply brief, and there were a lot from other states. Every state that looked at it made an exception for COVID and said there was no confrontation problem when you use Zoom for something like a huge public health crisis like COVID.
Do you think it matters that, this was a detective that testified, right? The Zoom.
Oh, yes, the main detective.
Would it be different if it were one of the major witnesses that had maybe taken a deal in exchange for testimony? Would that be different?
I don't think that it would.
Why not?
I mean, I'm thinking of even from the beginning when we started to have televised, where a child sexual victim didn't have to be in the courtroom with the defendant. That has all been upheld. And it's just, it has been upheld. If they wanted to argue that somehow it would take away from someone's testimony, the defense would be completely free to do that.
I mean, I think like if you have a different situation where somebody gets a deal for testifying and then they actually have to go into the courtroom and look at the defendant in the face, it's a very different situation than a Zoom call, right? You'd agree with that?
Yes, and I would, if I was a defense attorney, I would be arguing that. But the thing that's kind of hard here is you had the witness, and I don't know if this would apply if it was a co-defendant or a cooperating witness, but there was testimony, he was really sick. It's the worst sore throat he had in his life. He, I guess, sounded terrible. And even if you had a co-defendant or, as you're saying, another witness, and you can see that they are extremely ill and that is the reason it has, you couldn't ascribe some kind of to them not wanting to be in the courtroom because they don't want to face the defendant. It just.
Well, I'm just wondering if the type of witness matters in our evaluation of whether Zoom was okay in this case, because
I haven't read any case where that was a factor.
Okay.
And I did read a lot, tried to look up other states that they said were more strict on this issue. And in Ohio, and I haven't seen the type of witness ever discussed.
Okay.
Was there any other way to manage this situation? Like, could the trial have been continued in progress? Were there other witnesses to come? Could this detective have testified later once he was better?
It was pretty late. He was there for most of the entire trial, sitting, I think he was the state's witness. Sat with the state. He was there. This happened towards the end. I don't think, the defense never said, we think this is important enough that we should continue it. I don't think either side. I think there might have been a short discussion and they had just said, no, we're not going to stop at this point. Because the trial had progressed so far. If everybody had been in agreement, yes, but I just think it was so far, no one was interested in that. None of the sides. On the Batson challenges, I would just stand with what I put in my brief, especially this juror 19. She could have been a man, as opposed to being a woman. She could have been any race. And it was her kind of this unusual fervor and intent that she kept showing about wanting to be on the jury. The case all talks about how the trial judge is the one who has to make credibility determinations, and that the appellate court should give deference to the trial judge because they're the ones watching everything going on. And the trial judge said, in this instance, I think it makes complete sense to challenge her.
What about 36, though?
The witness had, the juror had a domestic violence with her own family in the past, a son who had problems with the criminal justice system. I think those are pretty standard reasons that have been upheld.
Well, were there, I guess I was confused, I can ask this of appellant. There were other jurors that also had domestic violence charges. Were they on the jury? Do you know?
I know it's in the brief
Yeah.
saying what you're talking about, but it still is a person-by-person determination, and the trial judge is there to see, the juror's demeanor, tone of voice, attentiveness, lack of attentiveness, all of those factors are
Right.
for the judge to look at, and the judge saw this, and
But I guess that my question is if the prosecution says that we don't want this juror because they have a domestic violence charge, but then there's other jurors that end up on the jury and they have domestic violence charges, doesn't that show kind of evidence of pretext?
you could argue that, but there was much more. I don't think it's ever that clean. There was also this discussion about the son who has mental health issues, and then under, I don't know what circumstances, was involved in the criminal justice system, all things that can leave a very negative feeling, especially for a mother watching a child go through this. And then knowing that the domestic violence specifically had to do with her own family, there you've got more and more layers of information that I think could have affected the juror. And that is in the record, and the trial court was there to make these determinations.
Thank you. I think you're...
I was just going to say, am I about at the time? Okay.
Yeah.
Thank you very much.
Thank you. Ms. Peters, you have 4 minutes.
Not enough time, Your Honor, to discuss everything I want to, but.
Talk fast.
Okay. First, Judge Kinsley, we looked at the jury instructions, and it was a straight OJI instruction, and it didn't specifically mention a firearm, but it said that if the conduct would have caused murder, and we know what the conduct was. The conduct was she was shot. So if he didn't have a firearm, he couldn't have been the one who committed the attempted murder.
Unless they went under a complicity theory.
But they weren't instructed on a complicity theory, and I know counsel mentioned the case that was decided 2 weeks ago, or roughly. I know it was on May 17th because I looked it up myself and I saw it. It was State versus Arnold. I do not have the citation. I can get it for the court if it wants. But there is a big distinction between the Arnold case and this case. In the Arnold case, yes, there were 2 perpetrators, and in that Arnold case, the jury was instructed on complicity and aiding and abetting, and there was evidence of it. Here, again, there is no evidence of the aiding and abetting. So even though the jurors might have the right to enact lenity or to make a compromise verdict, the conviction still must be supported by sufficient evidence and not be against the manifest weight of evidence. In viewing this all in the total, we argue both, that this evidence was insufficient, and obviously in our 7th assignment of error, we argue that it was against the manifest weight of the evidence. Regarding the 6th assignment of error, which was the video, the Zoom. Now, 2 Supreme Court in Michigan and Tennessee have said Zoom does not satisfy the confrontation clause. Regardless, in that context, what we don't have.
Does the context matter? Does the witness matter, or is it never satisfies?
The witness could matter, and it should be noted that the state characterized Agent Hageman as its most critical witness.
The detective.
Yes.
Okay.
So that means Michael's right to confront him, to meet him face to face, was even that more paramount, because the jury then needed to be able to fully examine his credibility. And they couldn't do that because what we know from the record is that they only had a view of his face. We don't know in this case, and I'm not alleging that there were any improprieties, but we don't know what procedural safeguards were taken with the Zoom. And that is something that the trial court should have investigated before allowing the testimony.
Did defense counsel ask for a continuance of the trial until this witness was healthy?
No, they actually asked for the court not to allow them to allow the witness to testify, because this is the state made the choice of having him be last, and he was.
Yeah, but he got sick with COVID.
Right, but that was the state. The state took that risk. What if he had been in an automobile accident and was in a hospital?
Well, yeah, same thing.
So The state
Should the
made that
state be-
choice.
Should they be not allowed to have their most critical witness?
If they can't present it at trial on time and it's unreasonable to continue the trial, yes.
But that's the question, is it unreasonable to continue a trial if somebody's very sick and contagious?
But the trial court never examined that.
Okay.
So,
But the defense never asked for a continuance either. They just said that he shouldn't be allowed to testify at all.
and then in allowing him to testify, the trial court should have examined the safeguards that were made with the Zoom procedure. And it didn't.
Well, didn't it implicitly, I mean, I recall some description of, you know, the screen is about as big as the detective would be if he were here in person, and everyone can see him with the same sight lines that they would have, you know, et cetera.
Judge Kinsey, I'm not sure that the record actually bears all that out, because there were some allegations that, like, the defendants couldn't see him, and they would have had a better view probably if he was in person, that there was a question about that. And part of face-to-face is he has to see them. We don't know what view he had. And we know from the record that the jury only had his view of his face. So we don't know if he was, you know, tapping his, you know, knee nervously, or if, you know, or if he was looking around, and what other tells that might be that he wasn't being entirely credible.
And do we know what resources he may have been reviewing on his end, or what influences might have been in his environment?
We do not.
Were any questions asked about that?
I don't, not during his testimony, no.
You are at your time.
I'm at my time. So we respectfully request that you reverse Michael's conviction. Thank you.
Thank you. Thank you both for your arguments this morning. The case is submitted, and we will issue a timely decision. And that concludes our cases for today. Everyone have a good rest of your day.